May it please the Court, good morning. This is an appeal of a summary judgment order from the Western District of Virginia in an age discrimination case. It's a single issue appeal, and that is whether the District Court erred by awarding summary judgment to the employer. There are four topics. The matter is well brief. There are four topics I propose to cover with the Court this morning. And first, the Court's principal error below was its failure to give credit to the direct evidence in this case, the Court finding that it was not temporally related to the termination. Second is the Court's failure to properly apply Reeves v. Sanders plumbing products, which we contend is dispositive of this case. The third is the Court's overarching error in violation of Poland v. Cotton, of looking at the evidence in the light most favorable to the non-moving party. And the fourth, and this is only if I have time, to talk about the distinction between a but-for cause versus the but-for cause, which is working its way through the lower courts. So first, the District Court below said that, yes, this direct evidence is evidence of discriminatory animus, but I can't consider it because it was not temporally related, that is, it was not close in time to the decision to terminate.
What is your best, this issue interests me, what is your best evidence of that temporal, contemporaneous existence of the age comment and the discharge?
Yes, sir. Judge Shedd, it's on page 404 and 405 of the transcript, the joint appendix, which is pages 85 and 86 of the transcript, and I want to turn there. Arthur's being questioned then about...
What page is it?
404.
Okay, 404. Okay.
Page 404, beginning with line 20, okay. Arthur is testifying. And then he says, and then in November he came to me. Now, November of 2009, just days before he was fired in December of 2009. He is the branch manager, Mike Reynolds. And then in November he came to me and asked me, he said, when are you going to quit? I said, Mike, I done told you that I'm going to work until my full retirement age of 66. I think he was 59 at the time. He said, well, I think you need to go ahead and hang it up because you're just too old to do your job. I said, well, I've been doing it. What's the difference? Now I'm in good health. I can still work. Then after that is when he went back to Merrill Smith and the letter was written. That's the letter of December 4, 2009, which was days before he was fired. And so on this particular point, the district court just got it wrong, and I don't know why, because we had briefed it for the court. It's in our summary judgment brief. We argued it before the court, but on this factual finding...
Well, I think if I read the judge's order correctly, it seems to me that maybe when he asked the question I just asked, different pages were offered up to him at oral argument. Am I wrong about that?
I don't know.
Well, you read his order, it certainly appears the only way you can read it, because I went back and read those pages, and quite frankly, they appear to end up what Judge Moon said. But this is a new page, but you say this is a comment that the supervisor says, well, I think you need to go and hang it up because you're just too old to do your job. And you say that was days before the dismissal?
Yes, sir.
Okay.
November of 2009, because Judge Shedd, if you look at the very next lines, which I'm repeating myself now, lines 4 and 5 on page 86 of the transcript, 405 of the joint appendix, then after that is when he went back to Merrill Smith and so forth. So this statement was made days before he was fired.
When was he fired? It was weeks later, right?
Yeah, or in December of 2009, yes. So weeks later, less than 30 days later, I can't tell you exactly when this statement was made in November of 2009. So Judge Thacker, at most, it was a matter of weeks before he was fired. And there's all sorts of precedent. We've cited on brief that a month before, 2 months before, 6 months before, whatever the case may be, is all deemed sufficient by the court. So this is the principal error of the district court below, and had it found the way that we think it should have found, there'd be no McDonnell-Douglas analysis. We'd just gone to the direct evidence analysis, and the case would have gone on to trial. And the direct evidence is here. You can read it for yourself. You can see it started with this first day of work. He asked 2 questions. What's your name? How old are you? You're too old to be working here. I'm going to get rid of you. And then Mike Reynolds got rid of every single older driver.
So what about the complaints
yes, sir.
that were detailed in Ms.
Yes, sir.
Smith's letter.
Yes, sir.
Are they, I mean, is it disputed that she received the evidence of, she's the director of nutrition
Right.
from the Lynchburg school system. Is it disputed that she received evidence from something like 5 of 19 units about Mr. Arthur?
It is not disputed, Judge Wilkinson, that there were complaints about Arthur's work to some extent reflected in that December 4 letter. I draw your attention to why that letter exists at all. It exists because Mike Reynolds went to her and said, I want you to help me get rid of Ralph Arthur.
Is it disputed that she threatened to terminate the account if Arthur was not removed?
The letter says what it says. The letter says what, I can't dispute the contents of the letter.
And the letter documents complaints that have been occurring about Mr. Arthur for a long period of time, not just after she may have talked to Mr. Reynolds.
Right. Back to at least August of 2009. And that's why this case is no different than Reeves versus Sanders Plumbing Products. Listen to the complaints in that case about the plaintiff. Here are the complaints concerning the plaintiff there.
Let me say this. I think you might have been wise to start with your direct evidence case. You're answering questions about the prima facie. If they did get a complaint about him, that might well do away with your prima facie case, but you don't think you need that to win this case, do you?
I don't need that to win that case.
So while you're attacking that letter, and you have attacked it, your attack on that letter and the result of what we think about that letter doesn't matter to your summary judgment opposition, does it?
It does not, but I didn't want to avoid your question.
No. I was just getting it straight in my mind while you were answering it. But
right.
your position would be, as I understand it here this morning,
Right.
is that we do have direct evidence. We defeat summary judgment based on that direct evidence. Then they can offer that letter if they want to as evidence and let a jury decide. You might have some argument about what the charge is.
Yes.
Right.
That's my
Of course,
fourth.
the other drivers were within the protected age group. Some of them were older than Mr. Arthur, and
No.
you know when it was
No.
well, when the route was divvied up, there was only one driver who was age 32, younger than the outside the protected age group.
No, Judge Wilkinson. Arthur was the oldest driver at the time he was fired. Now, again, I'm pushed over, and I don't mind arguing, but I'm pushed over to arguing the third prong of McDonnell Douglas, and I shouldn't be there at all. Take a look at page 142 of
But
Reeves.
the overall question we have to ask, no matter what, is what was the reason for the termination? Now, were these complaints false? I mean, as Judge Thacker points out, they go back for a long number of years, and they concern things, and that are pretty serious, including some driving accidents. And the letter says, I received calls with complaints that he's driving when entering school grounds is too fast, has created risky situations with other delivery trucks as well as with staff members and possibly students entering the building. Now, that's what she says, and the school board and the company are both on notice. And if they continue to let him drive and a student gets seriously injured in the parking lot, or a staff member gets seriously injured in the parking lot, there's going to be a lawsuit saying, what were you thinking about? You had notice. This was brought to your attention about this driving record and the risk it was creating, and you went ahead.
My response, Your Honor, is, and I don't know how many times I've stood here and argued before Judge Wilkinson, heard you call that grist for the mill. I should be making that argument to 7 people, not 3, because this case should have gone to a jury. Look at the complaints in Reeves. He was put on probation, 90 days probation for unsatisfactory performance. He intentionally falsified company pay records. He was guilty of shoddy record keeping. He did not act.
Who are we talking about now?
Reeves, the plaintiffs in Reeves versus Sanders.
All right, but let's talk about this case.
Yes.
Because one of the basic tenets of business is that you don't quarrel with a customer. If a customer, and in this case it was the leading customer from the person who held the account, and she's saying, I've got real problems. And if you're in business, you don't say, oh, no, you don't really have those problems. I can't believe she would have written the letter unless she had the problems. It's a detailed letter, and it contains serious things, which is that the crates were rolling through the cafeteria on wheels. If you've ever been in a hospital or a law firm or a cafeteria or any place with corridors, you're worried about it because somebody at a high rate of speed can knock somebody else off their feet. And then you have a broken hip in that situation. And what were they supposed to do? Is just ignore this? I mean, there's no evidence that she fabricated these complaints.
Your Honor, I'm about out of time now, but the complaints are based upon hearsay. They're not admissible on summary judgment.
But what's a decision maker supposed to do? Say, oh, this is hearsay. I wonder whether this fits within such and such an exception to Federal Rule of Evidence 803. I mean, people in the business world don't work that way.
Judge, the decision maker is the fellow who said, I want to get rid of Arthur because he's too old. And then he testified that I never said that. I never tried to get rid of Arthur, and it's not my fault. I didn't make the decision. Charlie Bem and Tony Hayward made it, and we deposed both of them, and they said no. So here's what the Supreme Court said. The Supreme Court said with respect to that particular point that the jury is entitled.
Isn't your argument, and that's the first time I saw that evidence today. You pointed out before, and I'm going to ask the other side about it. But your argument is all this stuff about complaint from a customer, which is valid.
Yes, sir.
In the business world.
Yes, sir.
You just say, here the problem is you have a decision maker saying, I'm going to get rid of you because you're old, and you think you should put that to the jury to see who they believe. You might lose. They might believe they fired him because of the complaint, but you think you're entitled to at least present the testimony that Reynolds told him a couple weeks before he fired him he was going to get rid of him because he's too old.
Yes, sir. Judge Wilkinson's argument is a jury argument. Every driver got complaints.
Look at summary judgment is never granted in an age discrimination case.
No.
Everything is a we said, he said situation, no matter how bad the record.
No. Look at our precedent in Wilhelm versus Bluebell, Lovelace versus Sherwin-Williams, Spagnuolo versus Whirlpool Corporation, and Reeves versus Sanders Plumbing Products. That's the precedent the court should be applying. And look, please, at page 707 of the joint appendix, every driver got complaints. They're milk drivers. You always got too much milk, too little milk. You're working too fast, you're working too slow. Like me, Judge Wilkinson.
Any previous driver have a complaint from the head of the largest account that Smith requested a meeting with Mr. Reynolds, number one, and then Smith threatened to terminate the account, and as I understand it, she had never threatened to do that with any. She'd never requested a meeting with Reynolds over any other driver, and she never threatened to terminate the account. if a driver wasn't dismissed. As I understand it, those were singular events.
She never requested a meeting concerning any driver, period. Any driver, period. Mike Reynolds said, I want you to help me get rid of me, and then she went along with it.
No, the meeting I think Judge Wilkinson's talking about the meeting in August of 2009.
Yes. Yes, there was a meeting in August of 2009, and they talked about Ralph Arthur, and there were some complaints based upon hearsay, and the jury should consider that. The jury should consider whether to render verdict for Art, which gets me, I'm out of time completely, to my overarching concern. The overarching error is the failure to look at the evidence in light most favorable to Arthur, which is what the Supreme Court reminded us last term in Tolan versus Cotton. Why do you think the Supreme Court took a garden variety abuse of force case to make the point that too many of these cases are getting kicked out on summary judgment?
Except there have been a great many summary judgment dispositions have been up before the Supreme Court, and certiorari has been denied after that case.
To be sure. To be sure. But that's the directive the Supreme Court provided.
It is not saying don't ever get a summary judgment no matter how bad somebody's, no matter how bad a loss a business is going to suffer, no matter what kind of danger is posed to students and staff in a school system, and no matter what the age of the workforce is, and no matter whether a meeting between the person who handled Pet Dairy's largest account and the individual and threatened to terminate the account if this individual was terminated, and those were unique events. There were other older drivers, and nobody ever went to this length to say this is an impossible situation.
There were no other older drivers. There were no. My time keeps running out. I keep getting more time, so I guess that's a good thing.
All right, well, you have some rebuttal.
I suspect you're losing it on the back end is what I suspect, but I don't know that.
All right, very well. I'll sit down then. Thank you very much for your time. I'll answer any questions that you might have, any additional questions. Thank you.
May it please the Court, my name is Victor Cardwell from the law firm of Woods Rogers. Along with my partner, Frank Friedman, I'm here on behalf of Pet Dairy. As an initial matter, Judge Shedd, you asked a question about the direct testimony or direct evidence on page 445, the joint appendix. I'll suggest, as in most things in this case, the Court needs to look very closely at the entire record, not just a portion, because that question did occur, and by plaintiff's testimony, somewhere in November of 2009, he said, and you should hang it up because you're too old. That's the testimony. But if the Court would read further, just a few lines down, I was deposing Mr. Reynolds, Mr. Arthur, and I said, when did you have that conversation with Mike Reynolds? I read directly from the transcript. He had it with me in November about me quitting again. November of 2009, my question. His answer, and I think this is illustrative to this entire case, 2009. I said, I'm going to quit. I'm going to quit until I'm at my full retirement, he said, that's Mike Reynolds. Well, okay. And he let it go at that. Mr. Arthur never consistently testified to any direct evidence.
No. That doesn't, you may be entitled to that inference. I mean, you're not entitled to that inference. If Mr. Reynolds says, if he says, you need to hang it up because you're too old to do your job, and the plaintiff goes, no, I want to stay, and he goes, okay, I'll just leave it at that. That doesn't mean that he didn't think or he wasn't motivated to fire him because of his age. You're taking the inference that on those two statements that aren't completely consistent, you get the inference that the statement, hang it up because you're too old to do your job, goes away. But it doesn't.
No, Judge,
you agree with me?
Absolutely, I'm good with you.
But then why isn't, listen, I looked through the record too, and
yes,
so
sir.
This honestly, quite frankly, is, I think, new to me this morning. But why isn't that enough to get the plaintiff past summary judgment on a direct evidence case?
Well, Your Honor, the but-for requirement of the analysis of the ADEA case requires that the plaintiff demonstrate the age, as this Court has articulated in prior case law, has to be the motivating, or the factor, not a motivating factor. In this particular instance, if that occurred in November of 2009, and you assume that it did, the intervening event of Ms. Smith penning a memo in great detail about the poor service would dictate that that's what the company had to respond to.
But by the way, isn't your argument, and it may be, isn't your argument the same whether this statement was made by Mr. Reynolds or not?
Absolutely it is, Your Honor, yes.
So your argument is what he said that you need. He has said, I'm going to get rid of you because you're too old. I'm going to fire you because you're too old. In the past.
Yes, sir.
But most recently he says you need to hang it up because you're just too old to do your job. Your assessment is this case is the same whether that statement's made by Reynolds or not made by Reynolds.
Judge Shedd, that's exactly right. That's exactly right. Our position is that the but-for cause requirement here was Mr. Arthur's long history of poor performance, which culminated in the memorandum. I think Judge Thacker properly pointed out, and Judge Wilkinson asked the question, what about the August of 2009 in-service before the school year started? And that was a result of complaints that the school had received over the course of time, Ms. Smith, had received over the course of many years.
It's not a question. How do we know for sure that that was the motivation for the firing? And how do we know under these facts that wasn't just a cover for the firing because of age? Your argument is if you get somebody else, some third factor person to say something, it wipes out. I'm not saying you did it. I'm saying it wipes out age discrimination.
No, Your Honor. I'm not suggesting that if someone actually engaged in the nefarious type of conduct that's been alleged here.
No, I'm not talking about nefarious. I'm talking about anything.
Well, what I would suggest is because of the but-for requirement, when a customer speaks in the industrial world today, in the business world today, our clients respond. We respond. And when a customer, over the history of time, over the course of time.
And the other thing is that letter it has two characteristics to it. She put her signature to it.
Yes.
You can't just, I think the appellant's trying to gin up a conspiracy, but you can't, she put her signature to it, and the complaints are detailed, and they stretch over many years, and they're from a variety of complainants, and they cover a variety of performance-based problems. She requests a meeting. She threatens to terminate the account if this individual is not terminated, and that wasn't done with other drivers. And I have not seen a case where a business is actually required to argue with the customer at the risk of losing its largest account and not to accept the customer's version of things. Oh, no, you're wrong. The customers can say, the heck with that. And not only is the business is required to put up with a risk of losing its largest account, but the school system is required to risk the safety of a school staff and faculty and students from someone whose driving record has been detailed. If you're on notice as a business and you're on notice as a school system that a driver is putting the physical safety of people in a parking lot at risk, and you say, oh, no problem, you're going to have a real problem on your hands. And I think the but-for cause is, the Supreme Court has not come close to outlawing summary judgment in these cases where you have something like this. That is a telling letter.
Your Honor, I would agree with you 100%. And to address any concerns about how it came to be, on direct examination, Ms. Smith in Joint Appendix 603, specifically, she was asked.
If we give you full credit for that letter, let me give you a hypothetical.
Yes, sir.
This is just a hypothetical. What if the defendants go, my God Almighty, that person's too old. We want to fire him because he's old. Gosh, when's the right time to fire him? We're going to get rid of him. The decision made, he is going because he's too old. And then the next day you get a complaint from your best customer. You then say, thank God that for that fortuitous event, we were going to fire him anyway, but now we have cover to do it. That's not age discrimination?
Judge Shedd?
That's not. You think that's not?
Under the Gross case of the Supreme Court, it is not. It's not actionable age discrimination. And what I would suggest to you on these facts, without the hypothetical, Ms. Smith was asked by Mr. Reynolds, not to help me get rid of him. He said, and I'm quoting Ms. Smith's deposition testimony on the question, I would like for you to put your concerns in writing.
No, listen, for purposes of my question, I'm not giving any credit to that conspiracy theory and all that, because it seems to me that's what a person does. If somebody complains, you go put it in writing, because if you don't, guess what? You get sued because that complaint was never made. I understand that.
To yours and Judge Wilkinson's questions, we should talk about Mr. Arthur as an employee.
But in addition to the history of complaints against Mr. Arthur, there's also a history of comments about his age, starting from the day he was hired till weeks before he was fired. So why isn't the jury entitled to consider that as to whether or not that is the but-for reason he was fired, particularly at this stage, at this summary judgment stage?
Judge Thacker, I believe that the court was proper in considering the temporal nature, the remote nature of the 2005 allegation. Again, plaintiff's testimony that Mr. Reynolds said, you're too old to be here. And then Mr. Reynolds himself was 40-some-odd years old at the time. The workforce there, as Judge Wilkinson properly noted, they're all over 40, save one person in this particular instance, and most are in their 50s and 60s. His age was not the issue. His speed and recklessness was the issue. The 2008 age comment, again, too remote in time, but notwithstanding all those things.
2009.
The 2009 comment is discussed with Judge Shedd. There was an intervention there. And once the school spoke, the client had to respond. And I'll tell you, Mr. Reynolds was operating with a history with Mr. Arthur. A history. Mr. Arthur tapped an SUV, which he initially did not have in the
The other history was Reynolds kept saying, I'm going to get rid of you because you're too old. That's a history, too.
It may very well be, Your Honor. It may very well be. But in this case, the but-for the causal reason for his termination was his job performance or lack thereof. He had a long history of job performance issues, and ultimately the school
And how do we know that?
His testimony, Mr. Arthur's testimony. I hit an SUV and it caused it to flip 3 times. Joint Appendix 446 through 447. I hit an SUV, I tapped it, but it flipped 3 times. Mr. Arthur got fired by Barnes & Noble for spilling a gallon of milk. Now, he got fired by a customer, and the school, and Mike Reynolds and Pet Dairy did not fire him at that point in time. They just replaced him and put him somewhere else. But he got fired by another client for spilling a gallon of milk. Mr. Arthur always has a reason, always has an excuse, but that's what happened. The school complained on numerous occasions before, even August of 2009, about receiving dirty milk and milk being left on the loading dock. Let's ponder that for a moment.
Seems to me you're making one heck of a good jury argument.
It's
That we did not fire him because of his age, despite the fact that his supervisor kept telling him that, and despite the fact the supervisor told him that a couple weeks before we fired him. We didn't fire him for that reason. We fired him because of his performance. And it seems to me that's a good jury argument, but I'm not quite sure how that letter and I accept the letter being completely valid, how that overrides the other evidence in the record.
Well, this court has previously addressed the but-for cause termination. Judge Wilson, Judge Thacker particularly, and I might say it wrong, Tavernier decision, Tavernier. It says a plaintiff bringing a disparaging treatment suit pursuant to ADEA must prove that age was not merely a motivating factor of the challenge adverse employment decision, but it was in fact its but-for cause. And here, this evidence is, the district court properly considered this evidence in light most favorable to plaintiff, or to the appellant, Mr. Arthur, and it concluded that on these facts, there was no way to demonstrate that age was not the but-for cause. I do believe if this court would look at this decision, I believe Judge Wilkinson's analysis is accurate. An employer who is serving the general populace, an employer who has customers, they have to be responsive to those complaints. And when you have a person, and Mr. Arthur was this person, he simply could not take responsibility. He refused to slow down. It's interesting, it's almost ironic that when you talk about age cases of the general matter, are they moving too slow? Are they not getting something done? Mr. Arthur was absolutely inopposite.
If a case like this goes to a jury, what you're saying to employers is that he said situation on these sorts of statements will override a detailed letter from the company's largest customer. And in the future, if he said is going to override this sort of letter, this sort of complaint, and I don't think doubt has been cast on its validity, then you're going to get school systems and you're going to get employers saying I don't know how, we can't do anything about this situation because we've got a he said, she said, or he said, which counts as direct evidence, and the courts, no matter how bad the performance issues and the rest, we can't do anything about this because the courts are going to regard it as a jury issue. And, that puts not only an employer but a school system in one very difficult situation.
Judge Wilkinson, it does indeed. That's exactly right. That's exactly.
Does Mr. Reynolds deny making any such statements?
Mr. Reynolds specifically denies making these comments.
Any age statements?
He feels as though they came out of whole cloth. Mike Reynolds will tell you that his best workers oftentimes are his more senior workers because they are dependable. And you're right. This is milk delivery, which means these drivers are leaving the facility at 3 to 4 o'clock a.m. to have milk delivered.
Particularly in these age discrimination cases, more than any other cases I know, there are statements about age that, even with a number of older drivers on the force, there are statements about age that can be, even when they talk about generational passage or whatever, people talk about age all the time. But if a dispute, a he said dispute over age, and they come up in this type of case more than in another, is going to override something like this letter. But it's not just the implications for business; it's the implications for school systems and customers, and whatever. It wreaks havoc.
I would suggest, Judge Wilson, you're exactly right. The danger here is that this is a pretty clear-cut employment decision. This was a clear-cut employment decision that resulted in a lawsuit, and that's exactly why Mike Reynolds was not the ultimate decision maker. The testimony was very clear that Mike Reynolds had a boss, a district or area manager. Mike Reynolds then had to, and Pet Dairy's protocol, as testified by Mr. Hayward, is any termination performance-based of this nature.
But we have these, if you look over these cases, you have these allegations of direct evidence of some age-related statement. In the age statements, for some reason, I think more frequently than in other cases, and I don't understand how somebody is driven by age animus when he's a fairly old person himself, and when other drivers on the force are in their late 50s or early 60s or whatever, they're not being fired. They'd have to do, if they were going to get rid of older people and senior drivers, they'd have to dismiss their whole driver workforce.
Maybe they haven't been fired yet. Is that possible? I mean, I don't want to. Listen, I think it's just going to come down to the law as you stated. That's not the law as I understand it. But I think you stated honestly that you can make all the assertions about firing you because of age, and if there's somebody else gives you some reason to do it, you're home free.
Judge,
that's your argument.
Yeah, no, it is. In essence,
I appreciate your honesty. You may be right on that. It just strikes me that's not right, but you may be right on it.
The fact is, and I think that Judge Wilkinson is more right, the reason a growth decision and age is treated differently than other factors under Title VII, for example, is that age is such a bright line event. Race is there. Gender is there. And those factors don't change, but we all get older.
But we're not. But I think Judge Shedd brings up a good point. We're not saying that everybody has free license to make all the age-related statements they want. It depends on the record in the particular case, and it depends on who the complaint was, how many complainants there were, what the detail was, how. It depends on the facts and circumstances of the performance regulation, the performance record in this case. And the thing that makes this, the damage this can do is that the record of poor performance was so strong. If the record were closer, it would be a certain thing. But this now is going to serve as some sort of benchmark that no matter how badly somebody performs, they can create this issue, and you can't do anything about it.
Judge Wilkinson, I think you're exactly right. And Judge Shedd, to be specific, when you asked me the hypothetical, could this occur? That was my response. And I believe that I could make an argument based on Gross and Tavernier that.
But that's your view.
Well,
that if there is a subsequent basis to get rid of someone, any comments about firing them because of age get washed out. That's your analysis.
if it's a proper intervening cause, Your Honor, it may very well be that is
I don't
my
know what
analysis.
proper is, but an intervening cause that could justify firing.
On these particular facts, the district court was proper in granting summary judgment because the documentation was there. Documentation was a result of a long-standing issue. Mr. Arthur had demonstrated over the course of time poor performance issues through the school, being fired by Barnes & Noble, tapping an SUV. He had those performance issues. Ultimately, it culminated in a situation where the largest client said, I can no longer have this person serve us. You need to get me a new person.
They actually, they stuck with him for a considerable period of time. I mean, I read this, and it seems to me that most companies would have dismissed him a good while back.
The district court was accurate in pointing out that even on 2005, when the first alleged statement was made, Mr. Arthur, like most of us, was simply an at-will employee. And had the bad actor really chose to or wanted to get rid of him, he could have done so any number of times in between. There were many events in between, from the Barnes & Noble event
Well,
to the bump.
you said it's different between gender and race. Why would your theory be any different there?
Well, the Gross case talked about how mixed motive factors can apply in those Title VII cases,
Right.
but in age cases in particular, it does not. And I can accept the congressional intent and the court's interpretation of that law. I see that my time is almost up. If there are no other questions,
Thank you, sir.
thank you.
Mr. Ryan, we're happy to hear from you in rebuttal.
In this case, you have Mike Reynolds saying that he had nothing to do with the termination and tried to save Arthur's job. A permissible inference from that is that he was performing at least satisfactorily to keep his job. Point two, with respect to the ages of the other drivers, Judge Wilkinson, Arthur was first replaced by a gentleman 23 years older than him. Arthur had the busiest route. That route was then redivided between individuals 8, 14, 16, and 36 years younger than him. Then the route was redivided again between people ages 14, 16, 17, and 25 years younger than him, one of whom was embezzling product from the company, a felony, and traveled with Mike Reynolds to the Caribbean. Arthur, who had performance issues, maybe like everybody else, was fired because he was too old to do the job. If you reverse this case, you may need to address the but-for cause versus a but-for cause. I simply draw to your attention two cases. The Fifth Circuit's case, Leal, L-E-A-L versus McHugh, 731 F3rd at 405, and a case from the the Middle District of North Carolina, EEOC versus City of Greensboro, 2010 U.S. District Lexus at 132159. If there are no additional questions, I'll rest. Thank you very much.
Thank you.